Welcome to Las Vegas Business, Bankruptcy, and Construction Law Podcast.
Hello, everyone, and welcome back to Las Vegas Business, Bankruptcy, and Construction Law Podcast, the podcast with attorney Tony May, where he unravels the complex landscape of construction law. I'm your host, Sean O'Connor, and today Tony is letting us in on how he manages construction claims for his Nevada clients, everything from contracts to mechanics, liens. And specifically today, Tony's going to weigh in on the power of the mechanics lien, one of Nevada's strongest payment tools. Tony, good to see you.
Great to be here.
You know, for the contractors out there listening, what are we, 2026 now? How does the mechanics lien work? You know, how does it actually force a payment when a developer or a homeowner is ghosting them?
So traditionally, like hundreds of years ago, before the mechanics liens, if a contractor came and worked on a building, a house, or whatever, and let's say there was a subcontractor and they didn't get paid, there was no way to collect against the house, against the homeowner, because they didn't have a contract with the homeowner. They had a contract with a general contractor. And so long time ago, the state started enacting mechanics lien laws. There's also a Miller Act, which is the federal government has different laws on that. But with the mechanics lien, each state has a means of setting up the ability for a contractor who provides labor, services, materials for the betterment of a property and enforces a way for them to get paid. It also, engineers, architects also can be included within this realm of potential lien claimants if they do a design on a project, the owner decides they don't want to pay the engineer architect, they can actually use the mechanics lien statutes to enforce their lien rights as well. So the bottom line is there are certain prerequisites to notifying the homeowner, the owner, and the contractor that they're there. And a lot of these things have to do with the relationship between the parties. For instance, if the owner of a project pays or doesn't pay the general contractor, the owner knows whether or not they're getting paid. If there's a dispute or whatever the reason is, the owner knows. The owner doesn't know whether or not the general contractor is paying the subcontractors or the suppliers. So the mechanics lien statute in Nevada and all over the country, they have a different way of trying to protect both sides and drawing a line between so that the subcontractors and contractors can get paid for their services, for bettering the property. And the homeowners also have a way of protecting themselves from having to pay twice. I've been involved in several claims where I represented the contractor and the owner had to pay twice because they didn't follow procedures in order to ensure that the subcontractor didn't get paid. Usually that happens when the owner pays the general contractor goes out of business or files bankruptcy, and then now the subcontractor is sitting out there and they use their lien rights in order to force payment. And so generally that's the way it goes. You follow the procedures, the statutory procedures, and if you do, you can end up foreclosing on the property because you have a priority against the owner's interest. For instance, if the owner buys a property, just a piece of land, and then hires a contractor, engineer, architects to design it, if the owner doesn't pay any of those individuals, they can put a lien on the property and basically take the owner's interests away from them all the way through the foreclosure process. That's how the contractors, architects, engineers, that's how they get paid if the owner refuses to pay them.
You know, you mentioned, the liens and I've got to imagine timing on this stuff matters. And I know Nevada has strict timelines, as do a lot of states. If a subcontractor misses their notice of right to lien window by even 1 day, let's say, is their claim effectively, dead in the water, dead on arrival? What happens there?
All right, so I guess two parts to this answer. First is the notice of right to lien is the notice that the subcontractor gives to the owner of the property, and basically tells the owner, "Hey, I'm here. I'm providing labor. I'm providing materials, and if I'm not paid, then I'm going to put a lien on your property."
And so that's something that the subcontractor would be giving to the owner, like at the top of the project?
Yes. All of my subcontractor clients, I over and over tell them the second you provide any labor or material to the project, you're supposed to send that lien. It's basically telling the homeowner, I'm here, I'm providing labor and materials, and if I don't get paid, I'm going to put a lien on your property. It's not a lien. It's not, threatening. It's just basically letting the homeowner know that they're there. That gives the homeowners the ability then from that point forward to protect themselves, to make sure that that subcontractor gets paid, by requiring the general contractor to give a lien release every time they make a subsequent payment. They want a lien release from the subcontractors to verify that they're all getting paid. And that's how the homeowner protects themselves. And then the notice of right to lien goes back 31 days. Let's say you waited 60 days, the subcontractor expects to get paid, but doesn't get paid, and waits 60 days, finds out he's not getting paid, and then puts the notice of right to lien. In that particular case, it's very likely that the subcontractor lost their lien rights because that notice only goes back 31 days. And so the only way you can get around that, there was a case, a Nevada Supreme Court case, where that happened to a subcontractor, and they went and appealed the decision. And the Supreme Court said, because I think that particular contractor had a big trailer on site that had their name, and that the owner actually went on site and saw that they basically were able to argue and convince the Supreme Court that the owner knew about it. And just because they didn't send the letter, the notice of right to lien, they made a mistake. That the Supreme Court said the owner knew about it. The owner wasn't damaged. There was no harm to the owner other than the fact that the owner didn't pay, which isn't considered a harm. And so the Supreme Court said, no, that it's good enough because you were able to prove that the owner knew you were there. Now, I always tell my subcontractor clients, don't make me go through that. It's expensive. Just send the notice out, and then make sure you keep track of it, certified mail, and keep all the proof so that I don't have to go down that road and fight for my clients. We just basically show the paper and we move on to the next step.
I'm wondering, like, from a homeowner's perspective, and I know you work on all sides of these sorts of cases, but from a homeowner's perspective, what is the full payment defense? And, how can they protect their property from a lien if they already paid the general contractor who then failed to pay the subs?
All right. So in Nevada, there's not a defense, and I've litigated cases and gone through where the owner had to pay twice. They paid the contractor in full, and the general contractor didn't pay the subs for whatever reason. The subcontractor puts a lien on the property, and now the contractor or the owner has a problem because the lien can be validated and they can still go ahead with the foreclosure process. Now, the first line of defense for homeowners is, again, once they get that notice of right to lien from the subcontractor, that they make sure the general contractor provides, there's two different types of lien releases or lien waivers. There's a conditional lien waiver that says, and these are all statutory based on Chapter 108 of the Nevada Revised Statutes, but the first one is a conditional. So when they submit their payment application, the owner should get a conditional lien release from the subcontractor saying, once I receive the money, I'm going to pay everyone below me, all my labor, everything. And once I receive the money, then this becomes valid. And then the next pay application process, when they submit the payment, the owner should require the general contractors to provide an unconditional lien release from each of the subcontractors for the prior payment application, verifying that they received the money and that the check's cleared and that everything is good. That's how the owners protect themselves in the state of Nevada. Now, there is some new statutes, new case law that potentially can be used to force the contractor to defend a lien claim. So, for instance, if I represent an owner of a project and a subcontractor puts a lien on the property and the general contractor didn't pay the sub for whatever reason, so the first thing I'm going to do is I'm going to send a demand letter to the general contractor saying you need to post a bond to bond off this lien because that's a dispute between you two, not between my client, the homeowner. And then if the general contractor posts a bond, the lien goes away on the property, and that bond becomes the the security for the subcontractor as the general contractor and the subcontractor fight it out. That's wonderful if the contractor is in business. If the general contractor is not in business, then obviously that doesn't work. And so, I mean, there's depending on the issues at hand, there's different ways to fight it. But in general, the homeowner needs to make sure through the lien waiver process that everyone is paid. That's how they get fully protected. And if they don't get the unconditional lien release on the second pay application, the homeowner can withhold payment from the general contractor for that amount until they get the security that the subcontractor was paid.
I'm curious, this is maybe a more broad question. I know, your background as an engineer, and, you're one of the few people I think in Nevada with, the engineering background and the law degree and working in this space. I'm curious how your background as a professional engineer helps you identify non-lienable work, right? Like soft costs or pre-construction services. A traditional lawyer might accidentally include them, right? Which then risks a frivolous lien charge. Is that something that, basically is it, that you're able, you're more adept at, so to speak? How does that come into play in advising your clients?
I do think that my engineering background plays a huge role in everything I do in construction law, for sure. Going through the design process, going through the back and forth, submitting applications, submitting plans, getting plans approved, going through that process provides me a big advantage on understanding the issues with contract disputes, because a design issue can relate to a construction issue back and forth. So I do think it does help me. Nevada has a pretty broad statutory basis for including within mechanics liens. But clearly understanding the design process helps you understand when something is lienable and when something is not lienable.
Of course, as always, we're running up against our time limit here for this episode, but I want to touch on something real quick, which is, most construction contracts now mandate arbitration. If you're in the middle of a private arbitration, do you still have to file a court action to foreclose on a lien, or does the lien sort of automatically expire while you're waiting for the arbiter's decision?
So for contractors, I would make sure that if there's an arbitration requirement within the contract, that there's an exception for the mechanics liens, because you cannot enforce a mechanics lien through arbitration because of the strict time frames. For instance, which we didn't talk about earlier, when you record a lien on a property, after you go through the process of all the notifications, and if you have a residential project, you have to actually put a 15-day notice of intent to lien. So first you start out with a notice of right to lien as soon as you start work as a subcontractor. General contractor doesn't have to do that. Then you, on a residential project, you have to give the owner notice, a 15-day notice of intent to lien, or notice of right to lien. Once you submit that, after that, you record the lien. That lien only lasts for 6 months. So if you're going through an arbitration process and it lasts more than 6 months, then you potentially would lose your lien, because as soon as that 6-month period is over, your right to a lien goes away. Your right to enforce the lien is gone. And so, you definitely, every contractor needs to file the lien, record the lien, file the lawsuit within the 6 months, regardless of what it says. And then you can stay, if you have to, stay the litigation process while the arbitration goes on. And then once it's done, you come back and enforce it through the court system. That's the way I would do it, regardless of what the contract says. But it's better if you have it in the contract that distinguishes this.
So much more to get into. Unfortunately, not right now. Tony, great to see you.
Great to be here, and thank you for giving me the opportunity to do this. I do appreciate it.
Thank you for listening to Las Vegas Business, Bankruptcy, and Construction Law Podcast. Navigating the legal landscape of construction is rarely a solo journey, and Maybrock Law is here to ensure your next move is a confident one. You want to get in touch with Tony, go to maybrocklaw.com. And you can get all the information you need there. If you like this episode, be sure to leave a review, share a link, subscribe. You know how to do it. Have a great day. Thanks for tuning in.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.